Well, fellow board members, ladies and gentlemen, Mr. Andrews, we have a couple of letters that I'd like to read, for the people that we've received through counsel from the District Attorney's Office. So they're quite lengthy, and I would appreciate your indulgence while I read through them. First one is dated December 4th, 2009, and it's addressed to Lauren Goldberg, Esquire of Copeland and Page, regarding the Wareham Board of Selectmen executive session of June 2nd, 2009, open meeting law. Dear Attorney Goldberg, this office has reviewed the information that you provided in the above-named open meeting law investigation. This office finds the Wareham Board of Selectmen, the board, violated the open meeting law in its discussions in executive sessions of May 26th and June 2nd, 2009, by discussing matters that exceeded the scope of the stated purpose, number 5, the investigation of charges of criminal misconduct or the filing of criminal complaints. General Law, Chapter 39, Section 23B, number 5. Mark Gifford requested this investigation because the board discussed his reputation in executive session on June 2nd, 2009, without providing him with the necessary rights under the open meeting law, General Law, Chapter 39, Section 23B, number 1. According to both the board and Mr. Gifford, the board posted a notice of a meeting scheduled for June 2nd at 6 p.m. with an incorporated agenda listed an executive session under purpose number 3 to discuss litigation. General Law, Chapter 39, Section 23B, number 3. The board has satisfied its burden to show that litigation was indeed discussed at the executive session. That litigation is ongoing, and any minutes relating to the executive session discussion of the ongoing litigation may be withheld from public inspection until the litigation is completed. However, the board's June 2nd open session minutes do not contain any reference to an open session prior to the executive session. The open meeting law requires that every governmental body convene first in an open session for which notice has been given and then vote to enter executive session. This office reminds the board of its obligations to begin every meeting in an open session, even when the board intends only to hold discussions in executive session, as required by the law, General Law, Chapter 39, Section 23B. The publicly available open session minutes must also reflect the purpose for the executive session announced in the open and vote of each member during the required roll call vote on whether to enter that executive session. The June 2nd executive session minutes, now in parentheses, though not the open session minutes, end of parentheses, reflect a recorded roll call vote to enter executive session under purpose number 5. It was permissible for the board to vote for and announce a second executive session purpose on June 2nd if done at properly posted open session. Purpose number 5 permits a governmental body to enter executive session, and then it says T, to investigate charges of criminal misconduct or to discuss the filing of criminal complaints. General Law, Chapter 39, Section 23B, number 5. This purpose did not appear on the agenda. There is no requirement for posting an agenda in the current version of the open meeting law statute. General Law, Chapter 39, 2 sections, 23A and 23B. If a governmental body posts an agenda, nothing in the statute prevents the body from discussing additional business outside the items listed in the agenda, as long as the additional purpose was properly announced in open session. Thus, there was no error in the posting of June 2nd's meeting. Part of the June 2nd executive session was broadcast to the public without the knowledge of the board. Because of this broadcast, the public learned that the board had undertaken a broad investigation of the town computers, a computer audit. As a result of the broadcast, Mr. Gifford later learned that one selectman made complaints about Mr. Gifford's reputation during the discussion in the June 2nd executive session. Mr. Gifford contacted this office because he was not afforded any advance notice that the board would engage in discussions about him. General Law, Chapter 39, Section 23B, number 1 through number 2. The board takes the position that these comments were not a discussion about Mr. Gifford because they were the comments of one individual selectman. This office does not accept the board's interpretation of the comments about Mr. Gifford. From the board's response to this investigation, it is apparent that the comments were made in the normal course of the discussion in executive session and represented one selectman's viewpoint during that discussion. Therefore, that statement is not exempt from scrutiny under the open meeting law simply because it was only voiced by one member. Purpose number 5 allows a governmental body to discuss investigations of potential criminal misconduct. The ensuing discussion must in fact be limited to an investigation of concerns about possible criminal conduct. The board is required to demonstrate that the executive session was in fact used to address such a concern rather than some other unstated purpose. General Law, Chapter 39, Section 23B, in parentheses, in any lawsuit, the governmental body has burden of proof to show that its actions complied with the open meeting law. End of parentheses. District Attorney for the Northwestern District versus the Board of Selectmen of Sunderland, 11 Mass Appellate Court, 663-664 of 1981. Collective bargaining purpose was deemed a pretext when no employees were present for purposes of bargaining. Puglisi versus School Committee of Whitman, 11 Mass Appellate Court, 142, 144 through 145, 1981. Executive session purpose to discuss reputation of superintendent was deemed to be a sham to hold a private discussion on firing of a school employee. The board has alleged that it had information giving rise to a concern that the town computers were used to commit a crime, namely criminal harassment or a civil rights violation. And it has a footnote number 1, which I'd like to read first. Number 1, the board suggests that another unrelated potential crime also justified an investigation under purpose number 5, but has not provided sufficient factual basis to support a reasonable or good faith belief that such a crime was occurring or had occurred. The complainant in the matter had reported the incident to the FBI and to this office. Neither the report to the FBI nor to this office contained an allegation about the use of town computers. On July 22, 2009, this office determined that the allegation by the complainant, though insulting, did not rise to the level of a crime. Even assuming that the board had a plausible belief that a crime had occurred, the board went beyond the scope of the executive session purpose on June 2nd, as shown below, on May 26th as well. Even if some discussion in executive session was justified to consider what to do about a possibility that town computers were being used to commit a violation of a person's civil rights, the executive discussion here quickly went beyond that limited topic. There is no support for the proposition that the comments about Mr. Gifford, his co-worker, and his department were connected to the allegations by the complainant or to any criminal investigation generally. The board admitted that the discussion of Mr. Gifford was not relevant to the criminal investigation under purpose number 5, calling them isolated remarks made by one official. Board members must strictly confine their executive session discussions to the cited purpose. District Attorney for the Northwestern District versus Board of Selectmen of Sunderland, 11 Mass Appellate Court, number 664. The minutes of the executive session that were provided to this office demonstrate that the board did not limit its session discussions to the complaint allegations of a potential crime or criminal misconduct generally. The discussions here addressed a more generalized town-wide audit of computer use, as well as deficiencies and new proposals for town computer usage unrelated to criminal activity. Puglisi versus School Committee of Whitman, Mass Appellate Court 144 through 145, in parentheses, though the committee cited a valid purpose, the committee was not permitted to discuss different subject and purpose in executive session. The executive session minutes of June 2nd and 2 prior executive sessions purport to explain the reason and purpose of the computer audit. On May 12th, while allegedly discussing a person's reputation under purpose number 1, the board decided that a computer audit was appropriate to deal with the problems raised, and it has sub number 2. Number 2, while the propriety of the May 12th, 2009 executive session was not one of the purposes of this inquiry requested by Mr. Gifford, the executive session minutes demonstrate that the board strayed beyond the strict purpose of the executive session on that day. For example, the board discussed an unrelated matter involving litigation. This office reminds the board that discussions in executive session are only permissible if they strictly confine to the purpose they to be discussed. District Attorney for the Northwestern District versus the Board of Selectmen of Sunderland, again, Mass Appellate Court. Also the Puglisi versus School Committee of Whitman, Mass Appellate Court 144 through 145. I just lost my place, forgive me. The problems went beyond the complaint that arguably raised a concern about possible criminal misconduct and addressed whether the town computers were more generally being used to criticize and denigrate people. The board planned a computer audit to see who is fueling this negative blog and to determine the amount of time employees are wasting on personal websites. This stated purpose is not related to a criminal investigation, as demonstrated in the May 26th and the June 2nd executive session minutes. Those private discussions had little, if any, content about criminal matters. The May 26th executive session minutes list the 6 goals of the computer audit. Only one of those goals even arguably appears to be related to the complainant's allegation of a crime. Although it is far broader than simply resolving that issue, only one other goal is even tangentially related to possible criminal activity. The remaining 4 goals are wholly civil in nature and appear to be related to employment matters. Further, the board had a completely unrelated discussion about a litigation matter on May 26th that cannot be construed as part of any criminal investigation. See District Attorney for the Northwestern District versus Board of Selectmen of Sunderland, Mass Appellate Court 664. Board's discussions contradicted claim that collective bargaining was the purpose of an executive session. Thus, the discussion of the general computer audit, as recorded in those minutes, cannot be properly characterized as limited to a criminal investigation where it was undertaken primarily to address non-criminal matters. Likewise, the June 2nd executive session discussion about the computer audit apparently focused on the details and costs of the audit. As stated above, the June 2nd discussion also included the statements about Mr. Gifford, another individual and their department without any connection to criminal matters. ID, your letter of July 27th indicates that a criminal investigation was at best only part of the computer audit. To the extent that the audit might result in evidence of use of the town computers for illegal purposes, such information could have criminal implications. See page 2, emphasis added. It is not sufficient justification for the generalized discussion of the computer audit under purpose number 5 that evidence of a crime could hypothetically be uncovered while the board is conducting an investigation into non-criminal or other matters. The board must actually be discussing a criminal investigation in order to meet privately under purpose number 5. The board must conduct its discussions about non-criminal matters or investigations publicly. Under some other permissible purpose under the open meeting law applies. Thus, even assuming that the board was permitted to enter executive session to investigate the potential civil rights violations or criminal harassment of the individual who complained to the board, the ensuing discussions far exceeded the limited scope of the purpose of the executive sessions by discussing a computer audit into other matters. Thus, the discussion on May 26th and June 2nd strayed far beyond the limited purpose of a discussion of a criminal investigation or criminal complaints. In these circumstances, the board has violated the open meeting law because it has failed to confine its discussions in executive session to the purpose of investigating potential criminal activity by discussing topics, including Mark Gifford, outside the scope of the purpose number 5 on May 26th and on June 2nd. As a remedy, the minutes of the executive sessions of May 26th and June 2nd must be made public records. The June 2nd discussion pertaining to the ongoing litigation may be redacted from the minutes before they are made public. Additionally, only the portions of the May 12th executive session that actually pertain to a discussion of reputation may be withheld from public inspection, and only till the purpose of the executive session is complete, but no longer. General Law, Chapter 39, Section 23B, Foudy versus Amherst Pelham Regional School Committee, 402 Mass. 179, 181 through 184, 1988. Minutes containing discussion of an employee were required to be released once the employee matter was completed. End of quote. Additionally, Mr. Gifford was denied his right to speak when his reputation was discussed at the June 2nd meeting. General Law, Chapter 39, Section 23B, Number 1. He must be given the opportunity to submit a letter, if he chooses, to be attached to the June 2nd executive session minutes. His co-worker, who was also named during that executive session, should also be given the opportunity, even though he has not requested this investigation, but it appears that his rights were similarly violated. Under General Law, Chapter 39, Section 23B, Number 1, this letter must also be attached to the executive session minutes of May 26th and June 2nd, 2009. Finally, the board must acknowledge at a properly posted open session that this office has found that it violated the open meeting law through an improper executive session on May 26th and June 2nd, 2009. When the board has informed this office that it has complied with these remedies, this matter will be closed. Please be advised that the legislature has amended the open meeting law. The board's obligations regarding posted notices, agendas, and the subjects to be discussed will change on that date. Acts and resolves, Stat 2009, Chapter 28, Section 20B, in parentheses, added July 1st, 2009, to take effect July 1st, 2010. And that is sincerely Mary Lee, Assistant District Attorney, Plymouth District. And that was to the Board of Selectmen through our attorney, Mark Gifford, and Steve Urban, South Coast Media Group. Well, that's the first letter, ladies and gentlemen, and if you just indulge me a quick drink, this second one is longer. Okay, the second letter we have, ladies and gentlemen, is to Brian Riley, Esquire of Copeland and Page, for the Board of Selectmen, open meeting law hiring. And it's again from the District Attorney's Office. Dear Attorney Riley, the Wareham Board of Selectmen, the board, voted to select a new town administrator on November 17, 2009, after a lengthy application and selection process. This office finds that the board has violated the open meeting law numerous times during the course of this process. The board improperly acted as its own preliminary screening committee or subcommittee and entered executive session to consider and to interview candidates for the position of town administrator under General Law, Chapter 39, Section 23B, Number 8. Even after the preliminary screening was completed and the finalists were chosen, the board continued to meet in executive session in order to discuss and consider the finalists for town administrator without any justification under the statute, General Law, Chapter 39, Section 23B, Number 8. The board improperly failed to record by roll call vote 2 sets of votes taken in executive session under General Law, Chapter 39, Section 23B. Despite its statutory obligation to provide minutes of open sessions within 10 days, the board failed to provide 4 sets of open session minutes to this office by November 19, 2009, after a request for all minutes relating to the hiring of the town administrator under General Law, Chapter 39, Section 23B, C 66, Section 10. The violations during this hiring process total 14. For 8 illegal executive sessions, at least 2 failures to record roll call votes in executive sessions, and failing to provide this office with 4 sets of open session minutes upon request. According to the board's response to this office, the Selectmen received applications from 21 people, 2 of whom requested confidentiality. According to the board's open session minutes of August 18, 2009, on page 7, the board actually received 22 applications. The open meeting law sets forth an executive session purpose to consider and interview applicants in private to ensure confidentiality under General Law, Chapter 39, Section 23B, Number 8, and that's Gerstein versus the Superintendent Search Screening Committee of Mass 465, 471, and 472 of 1989. Number 8, to consider and interview applicants for employment by a preliminary screening committee or a subcommittee appointed by a governmental body if an open meeting will have detrimental effect in obtaining qualified applicants, provided, however, that this clause shall not apply to any meeting, including meetings of a preliminary screening committee or a subcommittee appointed by a governmental body to consider and interview applicants who have passed a prior preliminary screening. General Law, Chapter 39, Section 23B, Number 8, emphasis added. Sections 23B specifically authorizes a preliminary screening committee to consider and interview applicants for employment, and to do so in executive session in circumstances properly found to have existed, unless the applicants have passed a prior preliminary screening, Gerstein, 401 Mass. Appellate 471, 472, in parentheses, 1 person asked for confidentiality. Thus, the board's explanation through your office on the need for privacy for employment applications is anticipated and provided for in the statute and case law. However, when hiring body wants to ensure confidentiality and privacy to applicants for employment, the hiring body may do so by appointing a separate preliminary screening committee or subcommittee. The privacy concerns do not justify any executive sessions by the hiring body itself. In order to conduct the selection process in private, the hiring body must appoint a preliminary screening committee or subcommittee under General Law, Chapter 39, Section 23B, Number 8. Only the preliminary screening committee or subcommittee may conduct the interview process in private, not the hiring body under General Law 39, Section 23B, under Number 8. The board relies upon 2 cases in discussing the need for privacy when considering job applicants, and they are Gerstein, a Mass Appellate Court, Attorney General versus School Committee of Northampton of 1978. However, in both those cases, the hiring body appointed a screening committee, again Gerstein, Attorney General versus the School Committee of Northampton. The school committee there advised 4 applicants for the position received more than 90 applications and appointed a screening committee to select candidates to be interviewed by the full school committee. The board has cited any case or any portion of the permits for hiring body to engage in executive sessions for the purpose of interviewing those job applicants. The explicit language of the statute itself restricts the use of executive sessions only for a preliminary screening committee or a subcommittee appointed by a governmental body under General Law, Chapter 39, Section 23B, under Number 8. No other executive session purpose carries this limitation, and that's under General Law, Chapter 39, Section 23B 1, 7, 9, and 10. Every other purpose may be used by the governmental body itself. An interpretation of the statute that permits the hiring body to use an executive session under purpose number 8 would essentially excise the words by a preliminary screening committee or a subcommittee appointed by a governmental body out of the statute entirely and rendered them meaningless. The rules of statutory construction do not permit an interpretation that ignores provisions inserted by the legislature. No portion of the statutory language may be deemed Fluis?
Superfluous.
Thank you.
Back.
Commonwealth versus Gove of Mass, 351, 354 in 1974. When the statutory language is plain, the words must receive their usual and natural meaning. ID, quoting Commonwealth versus Thomas of 1971, Tilton versus Haverhill, and that was back to 1942. Words and phrases shall be construed according to the common and approved use of the language. Under General Law, Chapter 4, Section 6, Clause 3, thus the Board's interpretation of Purpose Number 8 that would permit a hiring body to act as a preliminary screening committee does not comport with the explicit language of the statute or the requisite interpretation of the language under the rules of statutory construction. It's a good thing this went to a lawyer. The Board has suggested that the intent of Purpose Number 8 is fulfilled even when the Board acts as the preliminary screening committee, and that such an action furthers the same purpose. Purpose Number 8 was enacted to provide a measure of privacy to the candidates who did not pass a preliminary screening by a preliminary screening committee. The statute strikes a balance between the privacy of the applicants and the right of the public to hear the hiring body's views of the candidates who may eventually become public servants within the town. If a quorum of the hiring body, or as here, the hiring body itself, is present during the screening process in executive session, the public will never hear the comments of the members of the hiring body made in executive session as to the merits or deficiencies in the finalists, applications, or their prior experience of the individual finalists. If the hiring body is permitted to conduct the process in secret, the hiring decision can essentially be made with no public oversight. A result that is explicitly prohibited by the statute's provision, this clause, capital, shall not apply to any meeting, including meetings of a preliminary screening committee or a subcommittee appointed by a governmental body, again bold, to consider and interview applicants who have passed a prior preliminary screening under General Law, Chapter 39, Section 23B for number 8, and then emphasis added, therefore, the Board's interpretation of the statute that the Board as the hiring body was permitted to engage in executive session under Purpose Number 8 is incorrect. Neither the minutes that the Board provided to this office nor the minutes obtained from the Board's website demonstrate a good faith attempt to follow the statute. Even if the Board mistakenly believed that Purpose Number 8 permitted the hiring body to meet in executive session, the Board's response states only that the Board acted as the preliminary screening committee, not that the Board appointed itself as the preliminary screening committee. The Board has not provided and has not posted any minutes demonstrating that the Board voted to appoint itself as the preliminary screening committee in open session under General Law, Chapter 39, Section 23B for number 8. Purpose Number 8 only permits a preliminary screening committee appointed by said governmental body to engage in executive sessions under General Law, Chapter 39, Section 23B for number 8. The Board's response demonstrates that the Board did not take that procedural step of appointing itself as a subcommittee, but instead just started meeting in executive session to hire the new town administrator. While one member attempted to engage in a discussion of the procedure to be used, including the topic of a subcommittee as shown in the minutes of January 6, 2009, page 7, no vote to appoint a subcommittee was taken on that day, nor was any such vote taken on August 18, 2009, the last open session before the Board began the selection process in executive session. All votes taken in open session must be recorded in the minutes exactly. General Law, Chapter 39, Section 23B, Chapter 66, Section 5A. Thus, the evidence considered in this investigation demonstrates that the Board failed to even follow the necessary procedural step of appointing a subcommittee under Purpose Number 8 in open session to alert the public of an upcoming interview process that would take place in private under General Law, Chapter 39, Section 23B for number 8. The evidence shows that the Board engaged in 6 illegal executive sessions before narrowing the field of applicants to 3 finalists. The relevant executive sessions occurred as follows. On August 25, 2009, the board entered executive session and reduced the number of candidates to 9. Each candidate who received 3 votes would be deemed to be a finalist. The minutes of August 25, 2009 do not provide the board members recorded roll call votes stating their individual positions on whether to interview each applicant. Votes in executive session must be recorded, roll call votes. General Law, Chapter 39, Section 23B. All votes taken in executive session, in bold, shall be recorded by roll call votes and shall become part of the record of said executive sessions. Under General Law, Chapter 39, Section 23B, in parentheses, emphasis added, this failure to record the roll call votes that resulted in an interview process for 9 of the 22 applicants violated the Open Meeting Law, General Law, Chapter 39, Section 23B. On September 1, 2009, the board conducted 2 interviews in executive session. On September 3, 2009, the board conducted 3 interviews in executive session, and on September 8, 2009, the board convened an executive session to discuss the interview process, among other matters. On September 10, 2009, the board convened an executive session and interviewed 4 candidates. On September 14, 2009, the board convened an executive session and narrowed the pool of candidates to 4 finalists to be re-interviewed. Again, the executive session minutes do not contain the recorded roll call vote that narrowed the 9 applicants to 4 finalists. General Law, Chapter 39, Section 23B, instead, the September 14th minutes read, round-robin voting on 9 candidates, 4 chosen to be interviewed again. This failure to record the roll call votes that reduced the pool to 4 finalists violated Open Meeting Law, General Law, Chapter 39, Section 23B. These minutes show that the Wareham Board of Selectmen violated the Open Meeting Law 6 times between August 25th and September 14th, 2009, by meeting in 6 executive sessions to consider and interview applicants for the position of Town Administrator without any valid purpose and by failing to record at least 2 roll call votes as required by the statute. On October 3rd, 2009, the board held a meeting on a Saturday. During that meeting, 3 finalists were interviewed separately. The board has preferred that this meeting was open to the public. These minutes are silent as to the reason for the reduction of the number of finalists from 4 to 3. The Open Meeting Law requires that the board maintain accurate minutes. General Law, Chapter 39, Section 23B. The board failed to set forth the reason for the absence of the 4th finalist, whether it was from withdrawal by the finalist or by a vote of the board. If it was done by a vote of the board, that vote should have been a recorded roll call vote. Once the applicants passed a prior preliminary screening, there was no legal purpose to justify any executive sessions by the board or even a screening committee. General Law, Chapter 39, Section 23B, Number 8. However, on October 13th of 2009, the board met in executive session to discuss the selection process, Town Administrator search, a named individual to be told he is not a finalist. The 3 finalists to be interviewed on October 20th at the Selectmen's meeting, see minutes of October 13th, 2009 executive session, and parentheses. It should be noted that the identified individual referenced on October 13th was not the 4th finalist named on September 14th. Consequently, the executive session of October 13th, 2009 violated the Open Meeting Law of General Law, Chapter 39, Section 23B for Number 8. On October 20th, 2009, the Board of Selectmen interviewed 3 finalists in open session as required by the Open Meeting Law statute, General Law, Chapter 39, Section 23B, Number 8. On October 26, 2009, the Board met again in open session, and minutes reflect the following discussion. Selectman Cruz asked if the Board was going to vote on a Town Administrator. He said it was on the agenda, but not on the amended agenda. Chairman Savageaux stated that he removed it from the agenda because Selectman Cronin could not be in attendance, and he thought it was unfair for the board to take a vote without Mr. Cronin being there. Selectman Cruz asked why we couldn't vote anyway, as we stated at the last Selectmen's meeting that we would be voting on it tonight. Chairman Savageaux stated he did not want to leave Selectman Cronin out of the process, but the members could discuss their preferences if the applicants, could discuss their preferences in the applicants to gauge where we stood. A brief discussion ensued, each selectman's preferences. There was no clear consensus. It was recommended by Selectman Ekstrom that we wait to vote until the background checks are completed, as they may sway someone's vote. In the meantime, we could take the time to review the other candidates that were not our first choice to see if we could agree on one. Selectman Donahue concurred and also suggested that we should also wait to vote because this meeting was not being televised and people may want to hear our discussion. Selectman Cruz asked about what things could be or could not be in the contract, as there were specific issues he wanted addressed. Chairman Savageaux suggested we discuss the contract specifics at a later meeting, as it was time to adjourn to attend town meeting. On November 3rd, 2009, the board met once again in executive session for purpose number 3. The minutes state, discuss by charter, must be a 4/5 vote to approve candidate. Salary range not to exceed $110,000. The executive session of November 3rd, 2009 violated the Open Meeting Law, General Law, Chapter 39, Section 23B, for number 8. The board has attempted to justify its executive session discussions on October 13th and November 3rd that occurred after the board narrowed the field of applicants to 3 finalists on September 14th by citing purpose number 3, to conduct strategy sessions in preparation for negotiations with non-union personnel under General Law, Chapter 39, Section 23B, number 3. Underlined, District Attorney for the Northern District versus School Committee of Wayland, Mass 561, 568 of 2009, where, however, the board's minutes show that the board was not discussing contract negotiations, but was discussing the interview process in executive session. On October 13, 2009, there was no discussion of a contract at all. Instead, the board was concerned about breaking the news to a particular candidate who did not make the final cut. The board also discussed the process for the public interviews of the 3 candidates and the TA search generally. This private discussion was not permissible in executive session under purpose number 8 because the finalists had already been chosen, or under purpose number 3 because the board did not discuss the contract negotiations at all. Underlined, District Attorney for the Northern District versus School Committee of Wayland, again Mass at 568. And their discussion is where purpose number 8 prohibits the executive session discussion of a selection of a candidate after a prior preliminary screening. The board may not use a different executive session purpose to accomplish a prohibited private discussion, ID, in parentheses, where professional competence is precluded from executive session discussions under purpose number 1. A body may not use purpose number 3 to discuss professional competence for contract negotiations, end of parentheses. Further, the board's purpose for the executive session on October 13th to discuss strategy and preparation for contract negotiations required that it actually discuss contract negotiations. ID at 567, District Attorney for the Northwest District versus the Board of Selectmen of Sunderland, 11 Mass, Appellate Court of 1981. And that says, therefore, the October 13th executive session was conducted in violation of the open meeting law. On November 3rd, 2009, the executive session discussion revolved first around the upcoming vote for the town administrator. The remaining discussion about the amount of salary in the contract was permissible under purpose number 3. However, the board did not confine its executive session conversations to strategy for contract negotiations because the executive session included a discussion about the upcoming vote for the town administrator. And underlined is District Attorney for the Northern District versus the School Committee of Wayland. Thus, the discussion of the vote for the town administrator was required to take place in an open session, ID at 567 through 568. Therefore, the Wareham Board of Selectmen violated their open meeting law on October 13th and November 3rd, 2009 by discussing the town administrator search and their upcoming vote for town administrator in executive session after the completion of the screening process. These private discussions were impermissible. Additionally, on November 4th, 2009, this office requested that the board provide all the minutes, whether open or executive session, relating to the hiring of a new town administrator. The open session minutes were public records, General Law, Chapter 39, Section 23B. The board was required to provide them within 10 days of the request, General Law, Chapter 66, Section 10. This office permitted a 2-week response by November 19, 2009. On November 19th, the board provided the open session minutes for the meetings on October 3rd and October 26th of 2009. But a review of the open session minutes that are posted online shows that the board also discussed the hiring of a new town administrator on January 6th, 2009, August 18th, 2009, October 20th, 2009, and November 3rd, 2009. This board therefore violated the open meeting law and the public records law 4 times by failing to provide these 4 sets of minutes on November 19th, General Law, Chapter 39, Section 23B, General Law, Chapter 66, Section 10. The board's failure to comply with its statutory obligations require this office to discover that minutes were missing, make a new request for minutes, and then search the board's online website for the missing minutes. In total, the Wareham Board of Selectmen violated the open meeting law 8 times between August 25th and November 3rd, 2009 in the course of hiring process for the new town administrator by engaging in illegal executive sessions. The board violated the law twice by failing to record roll call votes taken during the executive sessions and narrowed the field from 22 candidates to 9, and then narrowed the pool of applicants from 9 to 4 finalists. The board violated the open meeting law and the public record law by failing to provide 4 sets of minutes. Thus, between August 25th and November 19th, 2009, the Board of Selectmen violated the open meeting law 14 times, and there's a number 2. The board is fully aware this is not the first time the board has failed to comply with its responsibilities under the open meeting law. Since 2006, the Wareham Board of Selectmen has violated the law 5 times, in addition to the 14 violations described above, demonstrating at least conscious disregard, at worst intentional decisions by the board to violate the statute. Under the case law, it is permissible in certain circumstances to withhold the names and identifying information about individuals who did not become finalists after preliminary screening. And that's underlined Gerstein, 405 Mass at 474, parentheses, there are substantial reasons for protecting the identity of individuals who were candidates only early in the process, end parentheses, from the Attorney General versus the School Committee of Northampton at 130-132. And that says it is not the fault of the individual candidates who applied for the job of Wareham Town Administrator that the board failed to abide by the open meeting law. Thus, their names may be redacted from the minutes. However, the current minutes are skeletal and provide no information to the public about the questions, concerns, or criteria that the selectmen used to decide which applicant was best suited for the position of town administrator. Thus, the public's right to observe has been denied. Therefore, as a remedy, the Wareham Board of Selectmen must announce publicly the board violated the law 6 times between August 25th and September 14th, 2009 in the hiring process for the town administrator by holding executive sessions without appointing a preliminary screening committee or subcommittee that consisted of less than a quorum of the board. The Wareham Board of Selectmen must announce publicly that the board violated the law 2 times between September 14th and November 3rd by discussing the search for town administrator in executive session without a valid purpose. The Wareham Board of Selectmen must announce publicly that it violated the law by failing to record a roll call vote in the executive session on August 25th, 2009, and again on September 14th, 2009, when it reduced the pool of applicants first to 9 candidates and then to 4 finalists. The Wareham Board of Selectmen must announce publicly that it violated the law 4 times by failing to provide minutes of open sessions upon request by November 19, 2009. The Wareham Board of Selectmen must release all its executive session minutes pertinent to the selection of the town administrator, which became public records upon the November 17th vote for the town administrator in open session under General Law, Chapter 39, Section 23B, in parentheses. Minutes of executive sessions must be released to the public upon request once the purpose of the executive session is completed, end parentheses. Those executive session minutes may be redacted to protect the names of the candidates who were not one of the 4 finalists. The Wareham Board of Selectmen must announce publicly in open session that it will not conduct such screening and interview processes in this manner in the future. These announcements must appear in the open session minutes of the meeting at which the announcement is made, to serve as a reminder to the board of its obligations under the law. Further, this letter must be attached to each of the executive session minutes in which the town administrator search was discussed to advise the public in perpetuity of these violations. These remedies must be completed by February 19, 2010. Upon receipt of a copy of the minutes of the session of the, upon receipt of the copy of the minutes of the open session where the Board of Selectmen complies with these remedies, and the minutes in which the board complied with the remedies set forth in my letter dated December 4th, 2009, read earlier. For an unrelated but equally serious set of violations, this office will close this investigation. Please be further advised that in any lawsuit filed in connection with an open meeting law, the board would have the burden of proving its compliance with the statute, General Law, Chapter 39, Section 23B, underlined, District Attorney for the Northern District versus School Committee of Wayland, Mass. at 566. Further, please be advised in such a lawsuit, the Superior Court judge may subject the board to a fine of $1,000 for each violation of the statute. General Law, Chapter 39, Section 23B, underlined, McCrae versus Flaherty, Appellate Court, 637, 639, 652 of 2008, where in parentheses $11,000 fines for 11 violations, but case was remanded for further hearings, case remains pending, end parentheses. Please be advised that the legislature has amended the open meeting law. Beginning July 1st, 2010, the Attorney General's office will have sole investigatory jurisdiction to enforce the statute. The board's obligation regarding posted notices, agendas, and subjects to be discussed will change on that date. Acts and resolves, Stat. 2009, Chapter 28, Section 20B, in parentheses, added July 1st, 2009, to take effect on July 1st, 2010. And this letter is signed Mary Lee, Assistant District Attorney, Plymouth District, and it is CC to the Wareham Board of Selectmen and to a Steve Urban of the South Coast Media. Ladies and gentlemen, that is our 2 letters that we have received, and for your information, Kopelman and Page has answered these letters. Thank you.